Hello and welcome to another edition of Legal Vaseline. Today what we are going to teach you is how to use the indexing system at the federal level. In other words, if you want to see how to look up laws and what they mean, it's fairly simple. It doesn't take much time. Let me start off with the United States Constitution, which is, according to Article 6, Clause 2, supposed to be the supreme law of the land. And I say supposed to be, that's what the founders intended. It doesn't normally work out that way. A case in point is the Second Amendment. The right of the people to keep and bear arms shall not be infringed. And of course, you'll see bumper stickers that say, what part of infringe do you not understand? Well, I can tell you who doesn't understand it. It's the federal judiciary and the Congress. Let me prove it to you. Look at this particular title here. Now, the United States Code, and remember, we're working at the federal level here, has 50 titles. Well, one of those titles has to be Title 18, Crimes and Criminal Procedure, Section 922 G1, which actually is the felon in possession statute. In other words, if you've had a felony conviction according to an act of Congress, you're going to federal prison. Now, the problem that we have here is that the Second Amendment says shall not be infringed. Well, that's an obvious infringement. And what we've got is what they call case law. Now, that's the law the judges have made for the rest of us, in which they explain a lot of their nonsense that they spout. And sometimes they get it right, but not in this one. Here's, and I'll prove it from their own citations. Look at this case here. Myers versus United States, 272 U.S. 52, 47, Supreme Court 2-1, 1926. And what it holds is that Congress cannot merely by legislating amend the Constitution. Well, that's what they did, because the Second Amendment never said the right of the people to keep and bear arms shall not be infringed unless they have a felony conviction. It doesn't say that at all. Now, there's an Eighth Circuit case in Young. Now, the circuit courts of appeals are the ones below the Supreme Court. And in Young, 141 Fed 3rd, 854, 8th Circuit, 1998, that's the name of the case. 141 Fed 3rd means it's the 141st volume of the Federal Reporters, 3rd series, and you go to page 854. And what you've got on that next level down is where most of the case law is made. In other words, that's where judges basically misinterpret the Constitution or whatever else they happen to be doing at the moment. Now, there's another case here, and this case here I think you're going to find somewhat interesting. United States versus Gomez, 92 Fed 3rd, 770. It's a Ninth Circuit case from 1996. Well, the Eighth Circuit covers places like Arkansas, Missouri, Iowa, places like that. You can look it up on the internet. But this Gomez case, it's a Ninth Circuit case originating in California, and the Ninth Circuit Court of Appeals basically covers Montana, Arizona, Nevada, and everything west, all the way up to the Western Pacific, the Marianas Islands. But this case is particularly interesting because it's a Second Amendment case in which the poor guy actually won the case, not after he'd done some time. But Gomez made the mistake of volunteering to help the feds while he was in jail, track down a guy, or not track down so much as help them prosecute a guy who was, this guy was absurd, he's a drug dealer. And of course, the feds fed him to the wolves. And so he bought a 12 gauge, bought a shotgun, and they held, in that case, there's a justification offense. In other words, there's nothing in the Second Amendment that says the right of the people can keep and bear arms, but they have to be justified. It doesn't say that at all, okay? Now, like I said, you might find this quite interesting if you read the case. You can pull it up on Google, actually. You can just put in 92 Fed 3rd, the page number, and it'll come up just like that. Now, the last case here, now remember, we've got the Supreme Court, the Courts of Appeals, and now we have the federal district courts. And this one here, in re grand jury application 6117 Fed Sup 199, Southern District of New York from 1985. It's a grand jury case that holds in districts of 4 million inhabitants or more that common citizens can go to the grand jury and petition for the redress of their grievances, or they've been a victim of a crime or whatever. Well, lots of luck with that one. The judges will stonewall you just about every time. There are other ways to deal with this. Now, we also have what are called secondary authorities, mostly law journal articles, things like that. They're not what's called controlling case law. In other words, the Supreme Court supposedly has the power to tell all the lower courts how to rule. The courts of appeal supposedly have the power to tell the district courts how to rule. And the district courts, they're not even considered precedent. Their decisions can only be used as guides. Now, there are other reporters, such as bankruptcy reporter and that sort of thing. But this is the basics. Once you learn this, you can read just about any article on the legal system. You can get a case citation, get a name or whatever. You'll have a pretty good idea of how it works. It's an indexing system. It's not magic. And of course, you're already halfway there if you know how to read and write. So, well, that's today's lesson, and I hope you learned something. Don't take my word for it. Read this this Gomez case. It's quite an eye-opener because it shows you all the ways that the feds. Well, in fact, the beginning of the case, the judges who authored it said they quoted Ronald Reagan's famous, "We're from the government, and we're here to help you." Scariest words in the English language. But if you read the case, you're going to see that this guy got himself in the jackpot by trying to be a good guy. I mean, it doesn't pay these days. Of course, look at the politicians we got. So the secondary authorities, like I said, law journal articles and so forth, but we will leave that for another day. We will also read the state indexing systems, but this should get you the basics. In fact, 40 years ago, I wrote a book titled Brown's Lawsuit Cookbook. In chapter 4, it goes much more in depth on how to use the indexing system. And there have been people that have won cases just using nothing but that book. And chapter 4, if you follow chapter 4 showing you how to use a law library, you can learn to use the indexing system in a law library, and people have done it in about 90 minutes. You're already halfway there if you can read and write. Yeah. Thank you for watching. I hope to be back at you soon with another edition of Legal Vaseline.